Hello, everyone. I'm chatting today with Kendra Connelly, who is a sales representative with Sotheby's, and we're going to speak about some real estate issues that buyers and sellers and maybe agents also have to deal with today. Kendra, do you want to tell us a little about yourself?
Hi, Tanya. Well, thank you for inviting me here, and thanks for joining me and willing to answer some questions. I think it's great. I consider myself a global real estate advisors with Sotheby's International. Been in the industry full time for 21 years, and just absolutely love my job.
And you're great at it. Amazing.
Thank you. Thank.
Hire her. Okay. Do you want to go into the questions a little bit?
Yeah. Thank you again. Thank you for taking the time to answer some of our questions. What are the biggest misconceptions that buyers have about the buying process that you come across a lot?
Okay, so um, there are 2 points that I've seen a lot happen quite a bit lately. The first is a buyer may think, well, I paid this 10, 15, $20,000 deposit, so if I don't close, I might just only lose a deposit. A buyer doesn't realize that if the buyer does not close, the seller can sue them for the difference between what they agreed to pay and what the seller ended up paying, selling the property for, which could be far over and above the deposit. So I had a matter maybe around 5 years ago where that was about 700,000 because there was a change in the market, and so the buyers weren't aware of that. So that's one problem I see. The second is that the bank will appraise the property for the amount the bank thinks it's worth. So sometimes a buyer will think, okay, I'm pre-approved for say 200,000, buy a property for 250, put down $50,000, go to the bank and say, okay, well, you approved me for 200,000, so provide that loan to me. And the bank says, well, the property is actually not worth that much to us. We appraise it and it's only worth 100,000. And then the buyer is stuck trying to obtain financing to make up that shortfall. So it's also important if a buyer is thinking about purchasing property, perhaps get a bank appraisal if they can before they put in that offer to see how much they would that buyers would obtain as a loan.
Yeah, having that financing condition to protect them. Yeah. And when
Yes, yes.
when clients, I give them options to remove that financing condition if they find themselves in a position where that could be advantageous for a seller to accept that offer from them. But I always let them know that that is probably one of the biggest risks, is that the property may not appraise at the price that you purchase it for, and therefore you will have a shortfall that you will be responsible for.
Yes, that's a great point. I mean, you have financing conditions for a reason and shouldn't just waive the financing condition because the bank says, okay, well, you'll be approved for X dollars. You should actually waive that condition once the financing has been confirmed.
That's right. Correct. Absolutely. So, if we were to jump over to the other side, what are some of the biggest misconceptions that sellers have about the actual selling process?
Think that sellers uh, have, I think there are two that the sellers have, and one is that they don't have to disclose hidden defects. So if a seller suspects that there's mold in the home, there was a termite problem, that something that a seller cannot detect with the naked eye, that the seller really should disclose that, because if you don't, then the seller could sue and possibly win. I mean, the buyer can sue and possibly win because the buyer was not able to detect that on their own. So I think sellers should disclose if there are problematic issues with the property that you wouldn't be able to tell just by walking through the property. Another point is that uh, seller, if the seller decides not to close or sell the property, changes his or her mind, the seller may be responsible for commissions due to the real estate agent. So I have seen situations where when we had more of a hot market, where the seller said agreed to sell the property, says, hey, I don't want to sell because I could sell to another person for more money. So the buyer, you may end up with a lawsuit from the buyer who buys a comparable property for much more. And also, if you don't use that real estate agent, you use another real estate agent, then you could also be subject to a lawsuit from that real estate agent for not closing for with that particular real estate agent and deciding to sell with someone else later on.
I have not had that happen. Knock on wood. I really don't want to have that happen. And again, absolutely disclose any, of those, defects and so on. Because at the end of the day, if you hire a good representative, and I have been in this situation before where you're selling a home, there may be an issue with the home, and a good representative will actually objection handle that for you. And what I find is if there's an issue, but you have a solution, then buyers don't figure it's so much of a large problem.
Yes,
So if you have a
exactly.
solution, you come with a solution, it seems to work out. So
Yes, that's true. That's true.
yeah. So this one is, I've got a question that's always sort of, I always hear different things from different brokers, different realtors, and so on. And so I'd love to hear your take on that. And that is, the agreement of purchase and sale states that the buyer will deliver the deposit check within what we consider a standard 24-hour period after the offer has been accepted. And the buyer does not deliver that deposit check, and they kind of get cold feet and decide, no, 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 I've changed my mind, I want out, and I'm not going to deliver the deposit check. In moving forward as a listing realtor, what should you do in that position that protects your seller and yourself?
I would think that the first thing you would do is confirm that there's a breach. So you put it in writing, like I confirm that the money was due on at this time on this day and it wasn't provided. So we confirm that you're in breach of the agreement. We'll mitigate our damages, meaning minimize our loss, and then we will relist the property, and you may be held responsible for the reduction in sale price. So that's the first thing I would do. The second is you would also have to evaluate the situation to see if the seller itself was in breach, because what the court has said is if a buyer is in breach, and the seller is also in breach, maybe did something wrong, didn't hand in something when the seller was supposed to, then both parties should work together to have a new date and a time to close. But here, if the buyer is explicitly clear, I'm not giving you the check, I'm not closing, then the second step would be to minimize damages, relist and sell it right away. Sometimes people kind of sit around waiting for a check to come their way, but a court doesn't like that situation. They want you to actively try and relist the property and sell it. You might sell it for less, you might sell it for more. If you sell it for less, then you probably will want to sue if the deposit doesn't make up for that deficiency. Another point with that is a deposit is usually held by a brokerage or oh sorry, the deposit wasn't even received. So
Yes.
no, that's not even a problem anymore. So you would relist and sell it. If there's deficiency, consider suing. But you also have to look at the assets the buyer has, because all a judge will say is whether you've won or lost. The judge doesn't actually, or the court doesn't actually actively help you collect your money.
Mm-hmm.
So maybe a buyer might not have any assets. So if you win the case, then and the buyer does not pay the damages, you can garnish their salary, garnish bank accounts, put a lien on their property, force the property to be sold in 6 months. However, if say this person is self-employed, it's a little bit more difficult to find out where those bank accounts are, doesn't have any assets in his or her name, so there's nothing to collect on. It may not even make sense to sue. So sometimes it makes sense to also work backwards to say, before I start this lawsuit, what are my chances of collecting? And after you decide maybe this person has assets, you have to monitor it from time to time. I had a situation where buyers didn't close, and our case took about 4 years to be dealt with due to COVID. And we monitored their properties that they had title in for a few months. And we noticed that right after we completed cross examinations, they changed title of their property into other corporations that they owned. So I received instructions to go behind their back essentially and make a request to a judge to freeze everything, called an injunction. So we froze all the assets, and they were not allowed to do anything with it until either we completed trial or we settled. So we were able to settle shortly afterwards. And last thing I would recommend a seller do is document as much as possible. Text messages, emails, or the agent. Text messages, emails are used in court. They're very good because it tells you what everybody was thinking at the time that the transaction should have occurred. And so it's really good. It's important to make sure that you don't do things on a handshake, or you just don't call and say you're not closing, but follow up with a documentation. And also even document any other sales or offers that you get. Make sure that's properly documented. If the sale falls through, make sure that's properly documented, the reason why. So that's helpful, especially if there's a huge shortfall.
Yeah, great advice on that one, because at the end of the day, you know, handshakes and verbal can work in other aspects, but where handshakes and verbal are not accepted, and especially in the court of law, is real estate transactions. Everything has to be in writing. So do yourself a favor and put everything in writing.
It is, and I mean I mean, a court or a judge will not ignore a handshake deal. I had a trial where it was a handshake deal, but because it was a handshake deal, it took a very long time to prove what the handshake deal was. And so I had to put pieces of paper together and emails and text messages say this is what everybody agreed on. So rather than have me spend 3 days proving what your deal was, it probably makes sense just to document it, and that will take about 5 minutes for a judge to deal with it.
Right. Yeah. And that's one thing that I've always appreciated about you, Tanya, and why I trust my clients with you, is because if somebody is thinking of getting into a litigation situation, you have real conversations with them about what it really looks like. And do you want to go down the road? And this is the cost, and this is the time and the stress and so on. And, you know, a lot of the times sellers or buyers will then sort of calm down and say, okay, actually, maybe I don't want to go down that road. So I always appreciate your candor with and honesty with clients. So
Thank you. Thank you.
um, so share with us what type of real estate disputes you sort of handle the most.
Well, I've seen an increase in four type of disputes. So the first is someone will obtain a mortgage, maybe from a secondary or a private lender, and then challenge the terms of the mortgage afterwards. We were successful recently in a case where the the mortgagor wanted the mortgage to be declared invalid for that reason. And the judge said, well, you both had independent legal advice. You've been paying this, like, just because you don't like these terms now doesn't mean that the court has to declare them invalid. So we were successful in that situation, but I haven't really seen that before, challenging the terms. Also, certificate of pending litigation. I've seen that quite a bit. So our firm won a certificate of pending litigation about 2-3 weeks ago. And so what a certificate of pending litigation is, you might be disputing that property. So it might, in this situation, for the purpose of our discussion, a seller might agree to sell a home to a buyer. The buyer needs that home for a specific purpose. So maybe the buyer needs that bungalow with a specific amount of rooms for the family, can't go up and downstairs as much. So there's a specific need for it. And so the seller says, okay, well, I'm not going to sell you the home anymore. I changed my mind. I could probably sell it to someone else for more money. And then that buyer says, no, I want specific performance. I want a court to order you sell to me because I need that home for a specific reason. And so if this takes a while to go to trial or have it or settle, the seller can then, the buyer can say to a judge, you know what, I want you to put a lien on this property to prevent it from being sold until the court deals with it. Because if it's sold, it defeats the purpose of specific performance, because I can't get into it with a third party. So I need you to put a lien on the property. So that's when a certificate of pending litigation is placed in the property. It doesn't really prevent the sale of the property to someone else, but people don't usually want to buy property that has a lien registered on title, and that cannot be removed unless the parties consent usually, or the court makes an order. You can get a temporary lien called caution, which lasts for about 45 days, but it's really intended for you to go to court and get your permanent lien. So I've seen that quite a bit, just disputes over property. The third are construction lien matters, like dealing with construction issues, contractor issues, where contractors say I'm not getting paid, or the owners of the property say the work wasn't completed properly. So I've been seeing those issues. And then last is partition and sale. So partition and sales, when you may have title of the you may have title of the property with someone like your spouse, and you say, I want to sell, and he says no, and no one can force him to sign on the dotted line. So then you would say, Tanya, I need to bring a partition and sale application because I don't want to be on title anymore. I don't want to own this property anymore. So it's a court ordering a judicial sale, essentially, saying put it on the open market, sell it, and then divide the proceeds among yourselves, because a court or a judge is not going to force somebody to stay on title if that person does not want to. So I've seen that happen, because I guess borrowing, everybody has a limited amount of borrowing power. And if you have title or on property or your name's on a mortgage, you may not um, you may not want it to be there anymore because you want to buy something else. So partition sales have gone up a lot,
Hmm.
and they're very hard to fight. I dealt with one last year, and the other side said, "Well, we agreed to hold the property for a certain period of time," and that goes back to what you said, Kendra. Document. So they said we agreed to, when we bought it, we agreed to hold the property for 2 or 3 years before we will sell it. There wasn't any documentation that speaks to that, and that's what the judge wanted to see. And because there wasn't any documentation spoke to that, then the judge ordered for the property to be sold. So that's when we represented the client on where we requested a partition sale, and it was ordered. So those are a few things that I see that are prevalent nowadays. And I'm not too sure if it's because of the market, um, but it is something that people are disputing over.
Yeah, I would, it's interesting that you say that you've seen an increase in that. I'm wondering if it's sort of just this sort of one of the last ripple effects of COVID.
Yes, could be,
So
could
yeah,
be.
yeah,
I see it a lot with
absolutely.
cottages because people I think thought, I could live in a cottage, and some people may be changing their mind, might change their mind, or their employer says, no, you have to come back to whatever the city.
Yeah.
And they say, okay, well, this is not going to work for me at this point in time.
Right. And the other spouse wants to stay.
Yes, another spouse or people Airbnbs, like people are purchasing properties for Airbnbs and or vacation rental by owner and realizing they just don't want to be involved in that anymore. And
Mhm.
so they don't want their name on title, they want to sell.
Right. Yeah. And so I've always wondered, like when you get a case or so, it's brought to you, how do you assess the strengths and weaknesses of a real estate case?
Well, there's really two factors: the evidence that's available, the written evidence, and the case law, right? So some people, if they have a handshake deal and it's going to be very difficult to prove what the agreement was or what happened, um, looking that's a problem. And then also, what does the case law say? Because there are statutes that speak to different things, but what's also important is the common law, and the common law means the judge made law, how they interpreted those statutes, and sometimes how they have interpreted statute is very different than what the statute says. So if the evidence is kind of on your side, the case law is on your side, and also if I'm representing the person who is suing and the other person has assets, that I would say, okay, it makes sense to sue if you can't settle, but always try to settle because you keep the power in your hands. It's confidential, it should be, and you never know. Like sometimes going to court is a gamble. You never know.
Yeah. Yeah. Well said. Thank you. Well,
Thank you.
I always appreciate your time, and like I said, there isn't anybody else that I would trust my clients' livelihoods in your hands at all times. So I always appreciate your words of wisdom and your candor.
Well, thank you. Thank you for speaking with me. Thank you for your great questions. They're very interesting, and the market is changing a little bit.
Yeah.
Interest rates were reduced, so I think that there probably will be further reductions, and that might bring a different type of litigation when it comes to real estate.
Yeah, I think that we always see different types of litigations, or we will see an increase of litigations when we are either in untrending market conditions. So things are just new and nobody's kind of been here before, or when we sort of find that the pendulum swings just, very strongly in the favor of one side of, a very strong seller's market or a very strong buyer's market, which of course we haven't seen that in decades.
So what do you see? Are you it's an off the cuff question, but
Yeah.
are you privy to any type of real estate disputes that you see going on nowadays?
Um, I mean, personally, not myself. We do hear through the grapevine, through, realtor, platforms where we might chat with each other of certain things going on. It's never really one specific thing. It's quite interesting how it's just really a mishmash of things that are sort of somewhat all over the board. I'm not surprised when you had mentioned about disclosing of your latent defects, because the provincial government did make some serious changes to how real estate transacted as of December 1st this year, or sorry, last year, so 2023. And they really sort of made some very serious information and disclosure about latent defects. So I think that that's just comes part and parcel with their just seeing all these issues. And so they're saying, okay, we're going to change the law here and to make it, even more prevalent and transparent is what they're trying to do when they're making those changes. And a lot of the changes that came into effect were in favor of the clients, or which I think is wonderful, and just created more transparency. But one of the aspects was about latent defects. And you actually
So,
you actually have to fill out a form now. The seller has to fill out a form that states that there are no defects or there are defects.
and just for the
I think
audience,
that's great.
latent defects are defects that are hidden, correct?
Correct. Yes.
Yes,
Yes,
hidden to
exactly.
the, yes. So,
Yeah, that it wouldn't be so easy for the human eye to see. Like a very common one can be water seepage, right? When it rains, if you have water seepage into your basement and it's not raining and you go in every time you see the home, it's a beautiful sunny day, right? You wouldn't know that, but maybe the seller knows that. Interestingly enough, I can share with you that I had a client who had said to me, I always ask the question, is there any, or are you aware of any water seepage in the home? So it just covers all areas from top to bottom, any water seepage. And he had said, well, I did have water come in through the door one time, years ago when we had that really flash flood. And this was years ago. There was like that. Now, this past summer, we've had a lot, but there was one about 7 years ago. And I said, well, did you do anything? He said, oh, yeah, we changed the drain. We, did the A, B, and C, and D. And I said, well, has it happened since? He said, no, it hasn't happened since. It's been about 7 years. I said, well, you know what? We're going to put that in the agreement of purchase and sale, that the buyer is going to acknowledge that it happened, that you had fixed it, and that it hadn't happened since. And at first the seller was like, but I don't have to. And I said, well, no, you don't have to, but it's better to have them acknowledge it. Sure enough, 6 months after that deal went through, that basement flooded in the exact same way. And that seller went to the lawyer and said, can I sue? And that lawyer looked at our agreement of purchase and sale and said, you acknowledged that it had happened, that they had fixed it. It hadn't happened again, but you acknowledged that. And so they didn't do anything wrong. They disclosed, even it was 7 years ago. So yeah, the seller was very happy. The original seller was very happy with me on that one. I don't do it all the time, but certain things, yeah, when there's something like that, I like to protect the clients, which is probably why I don't send you too many.
well, I really, that's one thing one of the many things I really like about you is that you're very diligent and very thorough. And it's great. It's great to hear.
Yeah.
So I hope people who are watching ensure that they are very thorough and diligent as well. Then you won't need me. So
That's right. That's right. That's right. That's what we say.
yeah. So Kendra, thank you so much for chatting with me. It was great to speak with
Yes.
you and answer some of the questions you have. And thank you for
Thank
sharing
you.
your knowledge with us as well.
Always. Thank you so much.
Okay, thanks.